Oh yes, oh yes, oh yes, the Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Tennessee Court of Appeals. Just a moment, we will talk about some basic procedures and before we call the docket. First of all, again, I want to thank you for being here this morning. I want to introduce your panel for this morning. We have Judge Neil McBrayer from, I say Nashville, but not necessarily so. Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Will be your panel for this morning. And looking at the docket, all of you appear to be experienced practitioners. I'm sure you know the procedures that we follow here, but I feel compelled to go over just a very few of them before we get started. Each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, please request that from the court after you've introduced yourself and before you begin your argument. You may reserve up to 5 minutes of rebuttal time. Obviously, the appellee gets no rebuttal time. Ms. Angie, anything to take up before we call the first case?
No, Your Honor.
You may call the first case then.
Kimberly D. Fisher et al. Versus Garrison Smith, M.D. et al.
Yes, sir.
May it please the court, my name is Everett Gibson of the Memphis Bar. I'd like to reserve 3 minutes for
Yes, sir. You may proceed.
First of all, I want to be sure it's clear to the court the nature of our motion for leave to amend. And it's described, that nature, in detail in the argument before Judge Atkins. The transcript of that argument is volume 5 of the record before this court. And at page 16 of that record, I made in the second full paragraph this statement: so all we have here is just a misnomer problem. And later in the fourth full paragraph on page 16 of volume 5, if the court will just permit us to correct a misnomer, everything is taken care of. We don't even have to change the name of the defendant. Just drop the PA. Interestingly, Judge Atkins started his ruling on the next page, 17 of the volume 5. I tend to agree with you that I don't think it is the embodiment of justice to handle these matters like this. But I think the Supreme Court has given us clear indication of what the law is on this in the Runyon's case and in the Bidwell case. I bring the nature of our motion for leave to amend to the attention of the court to distinguish this case from both Runyon's and Bidwell. Here's what happened. A year before the surgical injury in this case, March of 2019, the West Tennessee Medical Group Incorporated acquired assets of Jackson Surgical Associates, PA, asset acquisition. But they continued doing business as Jackson Surgical Associates thereafter, including on my client's first visit in January of 2020, and the surgery, which was scheduled for March the 3rd.
West Tennessee acquire include, did the assets that were acquired, did it include the name Jackson Medical Associates?
Apparently so. I can't recall seeing any of that in the paperwork on the asset
Because
acquisition. But
is there any dispute here that Jackson Medical Associates remained a separate viable entity?
the PA still exists, but the West Tennessee Medical Group has no control over it. And it is, we took some depositions, that's how I know this. The president of it, who's one of the surgical group physicians, says that they are still in existence because their accountant advised them that they could not end the corporate existence for 2 years after the acquisition under rules of the state medical group. So that's why they're still around, but they have no assets and they're going to be liquidated soon. But in any event, they kept West Tennessee Medical Group, continued doing business as Jackson Surgical Associates. Up to the time my client first went to them in January of 2020, and up to the time the surgery was performed, it was day surgery, on March 3rd, 2020. And even beyond that, they're still doing business as Jackson Surgical Associates, but there has been a change of location since this case was filed. But that's the only change, and the same physicians are doing the surgical work. And what this amounts to is there is confusion in the public, and we've documented that in this record by a Google search. Now, of course, a Google search is not evidence of anything but public confusion. They were still treating 2.5 years after the acquisition. On a Google search, they were still treating Jackson Medical Associates, PA, the professional association, as a group, a medical group practicing at such and such a place in Jackson. So it was certain in my mind, in my client's mind, the affidavit evidence will show, that she thought, and her husband thought, that they were doing business with Jackson Surgical Associates, not West Tennessee Medical Group. They didn't even know what that was. They don't live in Jackson. They live in Halliday, Tennessee, which is very close to the Tennessee River. And I don't live in Jackson, Tennessee. At the time we filed this lawsuit, our office was on Front Street, right next to the Mississippi River. So there was no reason for us to investigate, well, is this a valid corporation or not, Jackson Medical Associates.
Weren't you sent notice that that you had the wrong employer?
I'm sorry?
Didn't you receive notice that you had the wrong employer?
Yes, but that was after the statute of limitations would have run. So I filed a motion for an enlargement of time before being required to respond to their motions to dismiss, and supported it with an affidavit. And among other things, I said, we see confusion here, and here are the reasons why, and we want the opportunity to take limited discovery depositions of 3 people. There was no dispute where the defendant's counsel was concerned with our ability to depose the 2 named individuals who are named as defendants, who are affiants in supporting the motions to dismiss. But they did resist our taking the defendant physician, Dr. Smith's deposition. And so we had a hearing before Judge Atkins, and I believe it was in January of 2021, and he ruled in our favor on that motion, and we were permitted to take Dr. Smith's deposition on February of 2020. I beg your pardon, it was February of 2022, and we filed our response to the motion shortly thereafter. And then the next month, we had the hearing that I've quoted to the court. In any event, the record before this court, the affidavit of record, will establish there was confusion in the public mind over the relationship of West Tennessee Medical Group to Jackson Surgical Associates. And all we're asking, only relief we're asking is to be allowed to correct a misnomer.
How is that different than the Runyon's case?
Because in my mind, Your Honor, it's quite different because we're not going to change the defendant at all. We're just going to change the name of the defendant to conform to what the actual practice is. It's West Tennessee Medical Group doing business as Jackson Surgical Associates. And that's the same party that we sued, only we're dropping the PA. And I think that's a clear distinction from Runyon's and Bidwell. I don't want to use up any more time.
Yep.
Thank you.
You're fine.
May it please the court, I'm Craig Sanders, counsel for the appellees Dr. Smith and Jackson Surgical Associates, PA. We're here today because the plaintiffs ignored multiple letters they were sent pursuant to a statute that expressly told them 3 months before they filed this lawsuit exactly who Dr. Smith worked for and did not work for. A couple of facts I'd like to clear up. One, Dr. Smith began employment with West Tennessee Medical Group before Ms. Fisher ever became his patient, and that's set forth in the record in her affidavit. She says she was a patient starting in January 2020. Dr. Smith began employment with West Tennessee Medical Group in 2019. Following Ms. Fisher's surgery, she had some complications and sent pre-suit notice to several different potential defendants, including Dr. Smith and Jackson Surgical Associates, PA. She did that pursuant to Tennessee Code Annotated 2926-121, which is often referred to as the pre-suit notice provision in the Healthcare Liability Act. In response to that pre-suit notice, both Dr. Smith and Jackson Surgical Associates, PA, responded with separate letters within 30 days, pursuant to Section A5 of that statute, and told the plaintiffs that Dr. Smith did not work for Jackson Surgical Associates, PA, when he treated the patient, and that he worked for West Tennessee Medical Group, Inc., and also told them that that is a governmental entity. Both of these letters came from counsel, and it's undisputed that those were received. They were sent via email and regular mail and received by plaintiffs, and the trial court found that. And plaintiffs have not denied receiving those letters. Those letters are sent pursuant to subsection A5 that tells defendants if you receive pre-suit notice in a healthcare liability action, within 30 days you have to tell the plaintiff of any other potential defendant. And that's an amendment that came about in 2015. The defendants in this case did exactly what they were supposed to do pursuant to that statute and did it within 30 days. And we're here because those letters were ignored. Instead, the plaintiffs relied upon some research that they apparently did on the internet, which we all know is not always accurate and up to date. So once plaintiffs filed a lawsuit, 3 months after receiving these letters, who did they sue? They sued Dr. Smith and Jackson Surgical Associates, PA. So they sued the entity that they were expressly told did not employ Dr. Smith, and they did not sue West Tennessee Medical Group, Inc., which is the entity they were expressly told did employ him. Dr. Smith and Jackson Surgical Associates, PA, then filed motions to dismiss on separate grounds. Jackson Surgical Associates, PA's motions based on the fact they had no involvement in the case or in the care of the patient. They submitted undisputed affidavit from Dr. Dean Curry, who's the president of Jackson Surgical Associates, PA, that said we didn't employ Dr. Smith or anybody involved in this patient's care. We had no involvement whatsoever. So we can't be vicariously liable, and that was undisputed. Dr. Smith based his motion to dismiss on the Governmental Tort Liability Act. There's a provision in that act that says if you sue a healthcare provider individually, then you must sue their governmental employer. And that's expressed in the Governmental Tort Liability Act. It's been found by this court in cases including Braylon W. versus Dr. Walker, as well as by the Tennessee Supreme Court in multiple cases, including the Bidwell case, the Bidwell versus Stray case that's been cited. The trial court, after plaintiff was allowed to conduct the discovery that they needed, ruled on the motions. Plaintiffs, in responding to the motions dismissed, did file a motion to amend as well and asked to substitute West Tennessee Medical Group, Inc. for Jackson Surgical Associates. The trial court denied that motion and granted the motions to dismiss. The trial court denied the motion to amend on two separate independent grounds, either of which, according to the trial court, it had a basis to do. The first was futility, and it's exactly the same issue in Runyon's. Even if the plaintiff's motion to amend were granted and related back to the date of filing the complaint, it was futile. The plaintiff filed their complaint outside the one-year statute of limitations applicable to healthcare liability cases and relied on the 120-day extension that you're provided if you give pre-suit notice. So in the healthcare liability context, if a defendant or potential defendants provided pre-suit notice, the statute of limitations as to that defendant is extended by 120 days. The plaintiffs admittedly relied upon that 120 days that's set forth in their complaint in filing the complaint in this case. Since they did not give pre-suit notice to West Tennessee Healthcare, Inc., they only had 12 months to file a complaint against them. So even relating it back is futile, and that's the exact same situation that the Supreme Court was faced with in the Runyon's case. The trial court also based its denial of the motion to amend on undue delay, which is a separate independent ground on which appellate courts in this state have set forth is a valid reason for denying a motion to amend. In this case, the plaintiffs were told 3 months before they filed the lawsuit, according to a statute, who Dr. Smith did and did not work for. Yet they didn't file a motion to amend until over a year later. They were also told in the motions to dismiss, which were filed again, who Dr. Smith did and did not work for, and waited over 8 months after the motions to dismiss to move to amend. According to the Bowdoin case versus Long John Silver's, which is cited in the brief, this court affirmed a trial court for denying a motion to amend because the plaintiff was told at the outset of the litigation who the correct defendant was and waited, quote, several months. So in that case, several months was enough, and of course that's an abuse of discretion standard for the trial court in ruling on a motion to amend. I would like to speak briefly about the two key cases that I think govern this appeal, and that's the Runyon's case and the Bidwell case. I'll start with the Bidwell case, which is a 2021 Supreme Court case. In Bidwell, you had the same issue as you did here. The plaintiff sued two doctors, thought they still worked for a prior employer. Instead, they, at the time of treatment, worked for a governmental entity, Erlanger Hospital over in Chattanooga. The defendant doctors filed motions for summary judgment, which were granted by the trial court because, according to the GTLA, you have to sue the governmental employer if you're going to sue the governmental employee individually. Trial court granted the motions. Tennessee Supreme Court affirmed. Interestingly, in the Bidwell case, the defendants failed to comply with 2926-121A5, which is the provision that says within 30 days, if you get pre-suit notice, you got to tell the plaintiff if there's any other, quote, potential proper defendants. They failed to comply with that, and yet the Supreme Court, Tennessee Supreme Court, still affirmed because the GTLA does not contain an exception. If you sue the employee, you must sue their actual governmental employer, and they didn't do it in that case. The Runyon's case, which cites the Shockley case that came out of this court before the Runyon's case, very similar to this case as well. In that case, the plaintiff gave pre-suit notice to several related entities. West Tennessee Healthcare, Bolivar General Hospital, DBA Jackson Madison County General Hospital, and sued those entities. Did not give pre-suit notice to Jackson Madison County General Hospital District, and did not sue the district. Plaintiffs argued, well, the district is related to these other entities we gave pre-suit notice to. In fact, they're subsidiaries. They have the same registered agent, the same address. There's no doubt they got notice of the lawsuit. And the Supreme Court said that's not sufficient. To give pre-suit notice properly, it must be specifically directed to the defendant you're going to sue. The same principle that was set forth in the Shockley case, which was authored by Judge Stafford. So you can't give pre-suit notice to West Tennessee Medical Group, Inc. by giving it to Jackson Surgical Associates, PA, or anybody else. It has to be directed to that entity. I'd also like to talk briefly about that this is the same entity. It's not. Jackson Surgical Associates, PA is a private, for-profit corporation, completely separate from West Tennessee Medical Group, Inc., which is a nonprofit governmental entity.
Was West Tennessee Medical Group using Jackson Surgical Associates' name?
West Tennessee Medical Group, as set forth in the deposition testimony of Mr. Darrell King, who's the vice president of West Tennessee Medical Group, specifically testified they have never used Jackson Surgical Associates, PA, nor done business as them. What they have used is West Tennessee Medical Group, Jackson Surgical Associates, as a branding name. But those are separate entities, completely different. Also, West Tennessee Medical Group did not purchase the assets of Jackson Surgical Associates, PA. Jackson Madison County Hospital did that. I don't think it's important, but just wanted to clarify. So in this case, the defendants did everything they're supposed to do under the statute. All the plaintiffs had to do when they received those letters, which were mandated by statute, was to sue West Tennessee Medical Group. And he says, well, the statute's run. Well, we have the discovery rule in healthcare liability cases. I'd much rather be arguing that I didn't know the identity of the proper defendant than, well, I received these letters, but I'm still going to go ahead and sue Jackson Surgical Associates, PA. There was an argument to be made the plaintiff didn't make. The trial court had ample discretion to deny the motion to amend based on futility, also had ample reason to grant or to deny the motion to amend based on undue delay, and we would ask that this trial court affirm. Thank you.
Thank you. Mr. Gibson, you got 3 minutes.
The letters informing us that West Tennessee Medical Group is the party you should have sued, or words to that effect, were dated, I believe, March the 25th. It may have been March the 26th. But in any event, 3 weeks after the statute of limitations, the original 12 months, had run. So we couldn't run out and sue them or ask for permission to bring them into the lawsuit then, because we were beyond the statute of limitations. The remedy that we asked was to be allowed to take depositions. We got that relief. We acted with dispatch all the way from the time that the motions to dismiss were filed in August of 2021, 2021, to the time of the argument the following year on the motions to dismiss. We acted with dispatch all the way. We could not have gotten the matter resolved at the trial court level any sooner than we did, given the fact we needed this limited discovery. And from the limited discovery, we concluded that we have grounds for relief, and that is correcting a misnomer, so that we're not bringing in a new party. We're just putting the right name of the original party that received notice and was served with process within the 120-day period after the statute ran. they all knew that we had this claim against the Jackson Surgical Associates because 2 of the West Tennessee Medical Group employees were given notice. The parent corporation of the West Tennessee Medical Group was given notice, and the individual defendant was one of the two companies. Oh, and then the PA was given notice. So everybody knew what was going on, except we didn't realize there was a West Tennessee Medical Group connection with Jackson Surgical Associates. You couldn't tell it from the record. And if you'll go through my affidavit in support of the motion for leave to take discovery, filed in either August or September of 2021. You'll see from the exhibits where the confusion lay and why we should be allowed to correct it, Ms. Nolan. Thank you.
Thank you. Thank you, counsel, for your argument. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. Thank you. You may be excused.